Mr. President.
Senator from Missouri.
Mr. President, I rise today to urge the Senate to take action to crack down on child pornography offenders and to protect our children. This is a growing crisis, and it is one that is near to the heart of every parent in America. I can attest to that as a father of 3 small children myself. I've got a 9-year-old, a 7-year-old, and a 16-month-old baby at home. But I can also attest to it as a former prosecutor. As the Attorney General for the state of Missouri, one of the first things I did was to establish a statewide anti-human trafficking initiative and task force, because what I saw as Attorney General of my state was that human trafficking, including, unfortunately, child sex trafficking, is an exploding epidemic in my state and around our country. Children are exploited, children are trafficked, and those who work in this area, those who prosecute in this area, law enforcement, who work day in and day out will tell you that the explosion of child pornography is helping to drive this exploding epidemic of child sexual exploitation and child sex trafficking. The problem is that child porn itself is exploding. A New York Times investigative report found that in 2018 there were 45 million images of children being sexually exploited available on the internet. 45 million. Just a few years before, it had been 3 million. In 2018, 45. Then last year, the National Center for Missing and Exploited Children found that that number had grown to 85 million. 85 million images on the internet of children being brutally sexually exploited. And as every prosecutor and every law enforcement advocate and every law enforcement agent who works in this area will tell you, that explosion of this material, which, by the way, is harmful in and of itself, is exploitative in and of itself, is driving a crisis of child exploitation and child sex trafficking in this country. Now, the nomination of Judge Ketanji Brown Jackson to the Supreme Court has helped bring this issue front and center. Her record of leniency to child sex offenders has been much the center of her hearings, and it has startled the public. A recent Rasmussen survey found that following her hearings, 56% of all respondents said that they were troubled by her record on child sex offenders. That included 64% of independents. And they're right to be troubled. Her record is indeed startling. In every case involving child pornography where she had discretion, she sentenced below the federal sentencing guidelines, below the prosecutor's recommendations, and below the national averages. We now know that the national average for possession of child pornography, the national sentence imposed on average, is 68 months. Judge Jackson's average, 29.3 months. The national average sentence for distribution of child pornography, 135 months. Judge Jackson's average, 71.9 months. In fact, it's true for criminal sentencing across the board. The national average of all criminal sentences imposed in the United States, 45 months. Judge Jackson's average, 29.9 months. This is a record of leniency, in the words of the Republican leader, leniency to the extreme to child sex offenders and on criminal matters in general. But, we are told, and have been told for weeks on end now, it's not really her fault. We were told by the White House and Senate Democrats that it's not her fault because those federal sentencing guidelines that she, in every case where she could, went below, those guidelines aren't binding. Thanks to a decision of the Supreme Court by Justice Breyer, Justice Stevens, those guidelines are only advisory. And so we were told repeatedly that if we really want to get tougher sentences for child porn offenders, then we're going to have to change the law. In fact, I see my friend Senator Durbin here today, the chairman of the Judiciary Committee. He said this to me multiple times during the committee. On March the 22nd, he said to me, "I hope we will all agree that we want to do everything in our power to lessen the incidence of pornography and exploitation of children. I want to tell you, Congress doesn't have clean hands. We haven't touched this now for 15, 16, or 17 years." Senator Durbin went on, "We've created a situation because of our inattention and unwillingness to tackle an extremely controversial area in Congress and left it to the judges. I think we have to accept some responsibility." And he went on, I don't know if you, meaning me, have sponsored a bill to change this. I'll be looking for it. If we're going to tackle it, we should. Well, I agree with that, 100%. I agree we should tackle it. This is the time to tackle it, and I'm here to do that today. I'm proud to sponsor and introduce legislation along with my fellow Senators Mike Lee and Tom Tillis and Rick Scott and Ted Cruz to get tough on child porn offenders. Now, let's be clear. When Congress wrote the child pornography federal sentencing guidelines, and it is Congress that wrote them substantially way back in 2003, when Congress wrote them, they wanted them to be binding. Congress meant for these guidelines to bind federal judges. The Supreme Court struck that part of the guidelines down. Now it's time to put it back into place. My bill would create a new mandatory minimum sentence of 5 years for every child porn offender who possesses pornography. 5 years. If you do this crime, you ought to go to jail. It would make the guidelines binding for any and all facts that are found by a jury or found by a judge in a trial. Restore the law to what Congress intended back in 2003. Take away discretion from judges to be soft on crime and get tough on child sex offenders. That's what this bill would do. Now, I've called this bill the PROTECT Act of 2022 because it's modeled on the PROTECT Act of 2003 when Congress wrote these guidelines. And I just note for the record that I believe every senator voted for it back in 2003, including the chairman of the Judiciary Committee, Senator Durbin, and every member of the Judiciary Committee, Republican and Democrat, who was serving at the time. That act back in 2003 toughened penalties for child porn offenders, made the guidelines mandatory, and explicitly took away discretion from judges to sentence below the guidelines. I think it was a pretty good law, and I think now is the time to act. Our children are at risk. The epidemic of sexual assault, sexual exploitation, and victimization is real. And let's be clear on what child pornography is. It is an industry that feeds on the exploitation of the most vulnerable members of our society, that feeds on the spectator sport of child abuse and child victimization. If you have a lot of images of child pornography, you ought to go to jail for a long time. If you possess child pornography, you ought to go to jail for at least 5 years. And yes, it is time to tell every judge in America to get tough on child porn. That's what this bill would do. And I just urge the Senate now to take this opportunity to act. And so, as if in legislative session, I ask unanimous consent that the Committee on the Judiciary be discharged from further consideration of S. 3951 and the Senate proceed to its immediate consideration. I further ask that the bill be considered read a third time and passed, and that the motion to reconsider be considered made and laid upon the table.
Is there objection?
Mr. President,
Majority Whip.
reserving the right to object, I have to ask myself, why now? Why does the junior senator from Missouri bring this bill to the floor of the United States Senate today? When you think back, this matter has been considered. Originally, the guidelines were considered in 1984. The question of child pornography came back to us in 2003. In 2005, there was a Supreme Court case about applying the guidelines on sentencing to these types of cases, a case known as Booker. We know that in 2005, that decision was handed down. We know in 2012, the Sentencing Commission said to Congress and to the world, you need to do something here. These guidelines that you promulgated don't reflect the reality of today. We know as well that the guidelines were written, some were written in an era when the materials we're talking about were physical materials, and we now live in a world of internet and access to not just tens and hundreds, but thousands of images, if that is your decision. And all these things have happened, and we come here today. Today. I don't know exactly how many years the senator from Missouri has been in the Senate, but to my knowledge, this is his first bill on this subject that he has presented in the last few weeks. And I wonder why. Why now? Are there valid questions about sentencing guidelines? Certainly, there's no question about it. I said as much, and he quoted me. The Sentencing Commission told us over a decade ago, in 2012. You've got a problem here. The world has changed and the law doesn't reflect it. But this is the first time, to my knowledge, that the senator from Missouri or any Republican senator has tried to enact legislation on the subject. Why now? Well, I know why. He said as much. It's because we are now considering the nomination of Judge Ketanji Brown Jackson to the Supreme Court. And this senator has suggested over the course of the last 2 weeks in hearings before the Senate Judiciary Committee that somehow this judge aspiring to the Supreme Court is out of the mainstream when it comes to sentencing in child pornography cases. It's no coincidence that the senator from Missouri comes to the floor today while Judge Jackson's nomination is pending on the Senate calendar and has been discharged from our committee by a bipartisan vote of the Senate last night. It's no coincidence that he is raising this issue within hours or days before her confirmation vote. It's one more very transparent attempt to link Judge Ketanji Brown Jackson's confirmation with this highly emotional issue of federal sentencing when it comes to child pornography or child exploitation. There are some political groups, at least one well-known political group, that manufactures theories about child pornography and pedophilia and the like, and even inspires deadly reactions to them, and they're cheering this on. I've seen their reaction already this morning in the newspaper. They're watching this and hoping that someone can keep this issue alive on the floor of the United States Senate for them. The senator from Missouri has even gone so far as to make the outrageous claim that this woman, Judge Jackson, the mother of 2 wonderful girls who I had a chance to meet, a mother who comes to this issue not only as a judge, but as the daughter and niece of law enforcement officials who've been part of her family. In the words of the senator from Missouri, that this woman, quote, endangers children, close quote, endangers children. I'll yield when I'm finished. One conservative former prosecutor called Senator Hawley's charges, quote, meritless to the point of demagoguery. I've read so many reviews of the senator's charges against this judicial nominee. Not one of them gives him any credence. They basically say what you are dealing with here is a complicated area of the law, controversial area of the law, and to try to ascribe to this one nominee these motives, these outcomes, is baseless and meritless. Consider this. How can this judicial nominee possibly have the endorsement of the largest law enforcement organization in America, the Fraternal Order of Police, the endorsement of the International Association of Chiefs of Police, and many other law enforcement groups? How could she possibly have all that and be as wrong on a critical issue as the senator from Missouri has asserted? How is it possible that the American Bar Association took a look at all of her contacts as a judge, as a lawyer, as a law student, came up with 250 individuals who knew her personally, appeared in court with and against her, judged her in her individual capacity as a lawyer? How can the American Bar Association interview those 250 and find no evidence of the charges that have been made by the senator from Missouri? How is it possible that they would review all this and miss such a glaring fact? They didn't. They told us under oath that they asked point blank, is her sentencing standard soft on crime, different than other judges? The answer was no. No. And the net result of it was the American Bar Association found this nominee, whom the senator from Missouri charges with these outrageous claims, they found her to be unanimously well qualified. Unanimously well qualified. And yet the senator from Missouri believes that he's discovered something that the whole world's missed. Unfortunately, he's wrong, and he doesn't admit it. When Judge Jackson is confirmed to the Supreme Court, and I pray that she will be later this week, it will be in part because she is a thoughtful, dedicated person who has worked as a judge for over 10 years. She has published almost 600 written opinions. She has had 100 cases where she has imposed criminal sentences and a dozen or plus cases involving children. What the senator from Missouri has done is cherry-pick arguments from one small part of her service on the bench that has been debunked across the board. But let me say it again. Judge Jackson's sentences were appropriate exercises of discretion as a judge applying the law to the facts in difficult cases. And it's interesting to me how the senator from Missouri has carefully drawn lines to exclude Trump appointees to the bench who've done exactly what this judge has done as well, so-called deviate from the guidelines when it came to sentencing. In fact, one judge from his state, from the Eastern District of Missouri, whom he has personally endorsed as a good judge and may well be, has followed the same practice as this judge. Did he raise that at all in the Senate Judiciary Committee about the Missouri judge that was doing the same thing as Judge Jackson? No, nothing. There is nothing about these judges that is deviating from other than accepted practices. When 70 to 80% of the judges across America are using the same standard, Judge Jackson is in that mainstream, along with judges that this senator from Missouri has endorsed. If this issue needs to be addressed, and I believe it does, we can do so if we do it carefully, and we should do it carefully. Make no mistake, I don't back off from my words. As a father, as a grandfather, as a caring parent, I sincerely consider this to be one of the most serious crimes. The exploitation of children. I can't think of anything worse. And the pornography issue certainly is out of control because of the internet and because of those who are making a dollar on it. And we should take it very seriously, very seriously. It changes and destroys lives. But let's make sure we do this in the right way. What have we done on the Senate Judiciary Committee? It's great for the chairman to stand on the Senate floor and talk about the issue. Well, what have you done, Senator? Well, let me tell you what I've done, and I think the senator from Missouri knows it. We've done what we can to address this issue from many different angles. The committee held a hearing on the FBI's failure to properly investigate allegations against Larry Nassar for assaulting young athletes, Olympic gymnasts included, which enabled the abuse of dozens of additional victims. We called them on the carpet, we put them under oath, we brought the testimony forward. We didn't back away from the issue of child abuse. Following that hearing, I introduced the Eliminating Limits to Justice for Child Sex Abuse Victims Act with Senator Marsha Blackburn, a Republican from Tennessee. The Senate has now passed this bipartisan legislation, which would enable survivors of child sex abuse to seek civil damages in federal court, no matter how long it's taken the survivor to disclose the facts of the case. And the committee has unanimously reported a bill which the senator from Missouri knows well, the Earn It Act, legislation he has co-sponsored with Democratic Senator Blumenthal that will remove blanket immunity for the tech industry for violations of laws relating to online child sex abuse material. I have no apologies for our approach on this, and there is more work to be done. But I want to tell you, I'm tempted to leave it just at that, but for one thing I'm concerned about. Our federal sentencing guidelines have been advisory, not mandatory, since the Supreme Court's 2005 ruling in the Booker case. This bill, now being offered on the floor in a very quick fashion by the senator from Missouri, this bill attempts to create mandatory sentencing guidelines for a single category of offense. It's not clear whether it passes the constitutional test of Booker. It could be a waste of time. We don't need to waste time in a critical area of the law that has been so controversial and has been considered and reviewed over decades. Even so, it's a dangerous slope to go down. Imagine a world where every time it was politically advantageous, whether there was a Supreme Court nominee or a headline in the paper, that some senator could come forward, disagree with a federal judge on a particular case, and say, let's pass a mandatory minimum sentencing guideline to take care of the matter. That is no way to approach the law in a fashion that is used for deterrence and punishment. We need to be thoughtful about it, A subject of this seriousness, this gravity, deserves more than a drive-by on the floor of the United States Senate. I invite my colleague to do his work on this issue as we all should, the work that is required by the seriousness of this matter, and I object.
Mr. President.
Objection is heard.
Mr. President.
Senator from Missouri.
The senator asks why now? Why act now? Because it's a crisis now. Because there are 85 million images of children being exploited on the internet now. Because child exploitation is exploding in this country now. And today the senator lays bare on this floor the bait and switch that he and his colleagues have employed. They say, oh, Judge Jackson, it's not her fault. You should act in the law to change the law. But when we come to change the law and to do what this Congress did in 2003, to do it now in 2022, a measure that Senator Durbin supported in 2003, he says, oh, no, we don't need to act now. Why do it? It's rushed. It's too hurried. Let's do it later. Let's think about it longer. And then we hear recited again the bizarre claims that somehow child pornography is a conspiracy theory. This is something that the Senate Democrats, including the chairman, have repeated over and over and over, led by the White House. The idea that child exploitation is a conspiracy theory? I just invite you to look any parent in America in the eye and tell them that the exploitation of children is a conspiracy theory, or any law enforcement agent, or any prosecutor, or anyone who is working on the exploitation to combat the exploitation of children in this country. No, it's a crisis, and it's real. And the fact that the Senate hasn't acted till now is, I think, shameful for the Senate. But why wait another day? Now, I look forward, if the senator is serious, he does hold the gavel in the Judiciary Committee, we could mark this bill up. We could hold hearings. We could take action. I'd invite him to co-sponsor this bill. He voted for it in 2003. Let's have hearings then, if we can't vote on it today, if we can't debate it today. Let's have hearings. Let's mark it up. Let's take it seriously. I'll wait. I suspect I'll be waiting for an awfully long time. Here's the bottom line. I am not willing to tell the parents of my state that I sat by and did nothing. I am not willing to dismiss child exploitation as just some conspiracy theory. I am not willing to abandon the victims of this crime to their own devices and say, good luck to you. No, I'm not willing to do that. And nor am I willing to excuse Judge Jackson's record of leniency that does need to be corrected. She should not have had the discretion to sentence leniently in the extreme as she did, nor should any judge in America, in my view. So what's sauce for the goose is sauce for the gander. We should fix it for everybody across the board. And we can begin by acting as we did in 2003. So I'm disappointed, but I can't say that I'm surprised that this measure has been objected to today. And all I can say is I pledge to my constituents, I pledge to the parents of my state, and yes, to the victims of my state, that I will continue to come to this floor, that I will continue to seek passage of this act until we get action from this Senate to protect children and to punish child pornographers. I yield the floor.
Mr. President.
Majority Leader.
So after 27 minutes of debate on the floor of the Senate, the senator now believes we're prepared to change the law that has been debated for decades. He has put in a bill introduced 7 days ago. It's been 7 days he's had the passion for this issue, enough to introduce legislation. If you want to take on a serious issue, take it on seriously. And that means doing the homework on it. Yes, have a hearing. Of course, have a hearing. We want to make sure that people from the Sentencing Commission and others are part of this conversation. It isn't just a matter of throwing charges out against a nominee. And if you want to be serious about it, then admit the obvious. 70 to 80% of federal judges struggle with the same sentencing that we have set down, and in light of Supreme Court decisions, we understand that. Ask for order, Mr. President.
Ask for order. There was no response to begin with to the senator, so let's move forward.
So I would say, Mr. President, that as far as I am concerned, this is a serious matter that should be taken seriously. You don't become an expert by 7 days ago introducing a bill and say, I've got it. Don't change a word of it. Make it the law of the land. Make it apply to every court in the land. No, we're going to do this seriously. We're going to do it the right way. And we're going to tackle an issue that has been avoided for more than 2 decades when you look at the history of it. I find this reprehensible, the pornography, the sexploitation of children. There are no excuses whatsoever. But I'm not going to do this in a slipshod, make a headline manner. We're going to do it in a manner that is serious, that we work with prosecutors, defenders, judges, sentencing commission, and get it right. It's time to get it right. We wrote this law some 19 years ago, before the internet was as prevalent in society as it is today. Let us be mindful of that as we attack this problem and address it in a fashion that is befitting the Senate and the Senate Judiciary Committee. I yield the floor.
Mr. President.
Senator from Missouri.
Mr. President, the senator from Illinois says that Congress hasn't acted in 2 decades. That's true. I haven't been here for 2 decades. He has. There is no excuse to not take action now. There is no excuse to not act on this problem when we know what the solution is. So listen, if the senator is saying today, if he's committing today to holding hearings and marking up a bill to toughen the child pornography laws, to make mandatory the sentencing guidelines, that's fantastic. I'll take him at his word. I look forward to seeing those hearings noticed and to seeing that markup noticed. And I hope it'll be forthcoming. I'm here to make a prediction. I think we'll be waiting a very long time. Because let's not forget what his party and the Sentencing Commission, stacked with members of his party, have been recommending. It's not been to make child sentences tougher, child pornography sentences tougher. They've wanted to make them weaker. What the Sentencing Commission has recommended with its liberal members for years now is to make them weaker. That's what Judge Jackson has advocated. She also wants to change the guidelines to make them weaker. I think that's exactly the wrong move. And that's why the senator was here to block this effort today. He doesn't want to see tougher sentences. He doesn't want to talk about this issue. He wants to sweep it under the rug. I'm here to say I won't let that happen. I'll be here as long as it takes. I'll be agitating for this in the Senate Judiciary Committee as long as it takes until we get justice for the victims of child pornography and child exploitation. I yield the floor.
Under the previous order, the Senate stands in recess until 2:15 p.m.